In fact, it's a very important question, and I should say that our problem in Nigeria is never about laws. We have laws. We have, in fact, maybe too many of them, because in the business sector, the more regulation you have, the more potential for lack of coordination and coherence. Now, what we've seen play out here is that one of the key determinants of investment flow is legal and regulatory clarity and certainty, which we don't have. And that is often tied to the fact that policies change. One government comes in, tries this, and the other comes in and does not maintain that stability that is needed to drive market flow. So it's not about law, it's about lack of political will to implement existing laws. For example, in Nigeria, we already have the Investment Promotion Commission. It is their responsibility to be the one-stop shop for investments. They are there, and there is no way, and the law establishing them requires that even any treaty, any foreign agreement should be registered with them. So there is no way there will be an agreement between a Chinese company and a subnational, and the Investment Promotion Commission is not part of it. The Investment Promotion Commission is a federal agency, so they should be part of it. In fact, they should be the ones talking about this agreement and what they know about it. But when you have a situation whereby many of the existing bodies that should play this role are either not empowered to do so, or they are sidelined due to lack of political will, then you have these sort of problems. So let us go back to implementing existing laws. Let us go back to ensuring that our agencies are supported, are funded, and they are even provided the capacity to do their work without political interference. This is what serious countries do, those that are really, really keen to attract investors. Another thing is that when you have, in the business world, it is normal that when you are doing an agreement, you want to go with the strong person. And in the business world, that's why you see every agreement, you see a company wanting to have parent company guarantee, because they know that if there is a problem, the parent company is bigger than the subsidiary, so they can come and save the day. And in the same thing in international law, you see that many business folks want to deal with the federal government because they know that, well, if the subnationals fail, at least the federal government can step in. Now, what other countries do is to have a law or a provision that says, that gives indemnity to the federal government, to say that the federal government is indemnified of any liability that comes from any negotiation or deal that a subnational is trying to do. Do we have such indemnity provision? It's obvious we don't. And I'm very worried because now we are talking about local government autonomy. This is only going to get worse because a local government in Igbajo in Osun State can indeed go and sign a treaty with China or India, and then the federal government will be responsible for that. So we need these indemnity provisions or legislation that will make it clear to everyone that the federal government is indemnified of any transaction that the subnational is entering into, unless the federal government signs it or the federal government is carried along and is a party to it. And by federal government, we mean this will include agencies like the Investment Promotion Commission, allowing them to be part of such negotiations. Also, the third aspect is to look at capacity as well. Who negotiates international deals? It should be international lawyers. And when you have a situation whereby those that have no knowledge at all of international law are negotiating landmark international agreements, then they are opening the country up for international embarrassment, such as the one we are seeing right now.